I think it is mostly widely acknowledged at this point that there is so much that literature can offer to the study of law, especially legal history. When we think about, work like Charles Dickens as a legal historian, which is quite old at this point. I think it was published 1928, I want to say. That body of exploration demonstrates how rich literary narratives can contribute much to how we think about legal history and legal scholarship. And more contemporary work like Ian Ward, who published something, I want to say 2023, the Journal of Law and Literature, talks about how even poetry can hold much relevance for how we think about law and literature. But when I take up law and literature in my work, especially given the register in which I work, so decolonization, colonial histories, I'm especially interested in indigenous literature and how that body of work served pre-colonially for many indigenous communities to preserve and communicate their own normative, including legal systems. And so when I put law and literature methodology into my work, I'm interested in how law and literature helps us in a decolonial sense to resist the colonial narrativizing of indigenous peoples, indigenous communities, indigenous experiences, and instead allows us to turn to the methods that indigenous peoples have pre-colonially used to tell their own story. And for the communities that I have so far produced my research on, that method was literature, that method was storytelling. And so law and literature functions as a decolonial practice that moves me closer and closer to the ways that pre-colonial peoples understood themselves and communicated how they understood themselves beyond a colonial narrative that can be quite dominating. And some scholars have used the word can eclipse how pre-colonial peoples understood themselves. So I'm trying to get beyond that eclipse, and to get at the indigenous narrative using the methods that indigenous peoples have used. So that's one way in which I think literature can serve legal history, including within the international legal context, including within the context of colonial exploration and colonial studies.
Right, great. We'll be coming back to you in a second. Maybe if Ruth, you wanna, jump in.
Great. No, thank you. Thank you very much. And I'll just reiterate those thanks to the organisers for putting on this particular seminar series and this particular iteration of that. So when I was invited to come and talk about this topic, it spoke most clearly to work that I've done with Professor Aoife O'Donoghue at Queen's University Belfast on using utopian literature to kind of interrogate different aspects of international law and constitutional theory. So it's some of those ideas that I'm going to speak to today. And in relation to the very particular question we've been set, like how can law and literature or literary perspectives challenge and reshape our understanding of international law historical narratives? This question raised one of the pieces that we most recently published, which was about interrogating utopian fiction for its construction of the idea of place. And so what I want to talk to for a moment there is the synergies, if you like, between law and literature on how place is constructed, and what those synergies can then tell us and expose with respect to the structures of international law in relation to gender and colonialism. So what we were doing in that article was to take a series of early modern utopian texts, so thinking about Thomas More's Utopia, but also reading that alongside Francis Bacon's New Atlantis and Henry Neville's Isle of Pines. It's like a reading list for you all to go and read these kind of early modern utopias. And we sort of frame them as being very colonial utopias. If you read across these early early modern texts, what will very often happen at the start is that the island needs to be constructed, right? Thomas More's literally utopia is constructed as an island to carve out the landmass. But then the second thing that happens is the destruction of the indigenous communities there. The very idea of needing to construct what we in international law might call terra nullius, no one's land, no one's place. And that is a trope that then happens across a number of these early modern utopian fictions. And so these techniques of gender, of race, techniques of constructing hierarchies between peoples, the way in which people are dehumanized and therefore removed from the place, from the territory in these literary texts, mirror the ways in which kind of empire and colonialism used very similar, if not the same, techniques around the world. And we also explore alongside that the techniques of science. So thinking about the way in which in the novels themselves, ideas of mapping and of the drawing of maps and the drawing of territories is also a fundamental part of creating that idea of the place, and the way in which mapping then is used again as a tool of colonialism. Now, why do we center on this question of place? Well, in utopian literature, the utopia is both the no place. It's supposed to be an imaginary fictional place or destination that we might never get to, but it's also the good place. And a lot of emphasis is often in international law focused on that idea of the good. You know, what if international law is utopian? What's the good? What's the ideal? What are we striving for? And not so much attention has then been placed on the no place, this idea of the way in which international law, through these tools of gender, race, construction of hierarchies, ideas of place, very much was used as a tool to legitimize these colonial practices. So just to kind of give some like hideous examples from these novels to try and kind of give an example of what I'm talking about. In addition to that idea of Thomas More's utopia starting with the very destruction of the indigenous population, in the Isle of Pines, Neville does something very similar in terms of focusing on the idea that the island is empty. But what actually happens is that there are people that live there, but they are constructed as being wild people. And therefore, because of their practices, because of the racialization of their practices, they're considered and constructed out of the narrative. In terms of the question of gender, we see that throughout these colonial early modern utopias, common tropes of sexual slavery, misogyny, and indeed homophobia being used to construct these ideas of the utopias, the people, you know, the utopians, the people who've come and now live in utopia, being constructed as higher, as better than those indigenous populations in there. So there's fictionalized, racialized hierarchies in a number of the literatures. For example, the Isle of Pines, one of the characters is called Philippa. And her sexuality is described as ferocious, and her intelligence and her ability to bear pain are deeply embedded in racist tropes of her being less than human, and that this is then a justification for the way in which the utopians, those that are going to make the ideal society, can treat others there. So I think that again is one of the ways in which Aoife and I have worked to use law and literature to expose, if you like, the gendered and racialized constructions under international law. And perhaps then, shall I pause and we can go back?
Sorry. Ola, do you want to add anything? Jump in.
I mean, I don't know if it's so much as add or just affirm what Ruth has said, that, you know, it's always exciting to get into a session like this and have the ways that you're thinking about stuff be, affirmed or have it at least cohere with how other scholars in the field are thinking about it. And that's what Ruth's conversation just now did for me. Perhaps I will also include, and this is to connect the way that I apply law and literature in a decolonial register with gendered, with gender studies, let's say, but gender studies in the context of pre-colonial and, for my research at the moment, Igbo communities. One of the often reiterated themes in the conversation when we think about colonialism is this sense that, well, in the very least, it did something for women in the sense that it introduced ideas of like justice or equality that were missing in pre-colonial societies. And in the late 90s judicial decisions, we find places where the Nigerian courts, when applying the repugnancy doctrine, tends to reinforce the trope of, well, at least, the received English traditions, rule of law has done this good thing where it has allowed us to invalidate unacceptable cultural practices that characterized indigenous normative systems. And as much as we generally appreciate the harms of colonialism, there tends to be a whispered sense of, well, at least there were some things that it allowed us to get rid of. And one of those things that it allowed us to get rid of, as it were, is gendered oppression. And often we find that the way we represent pre-colonial communities is as manifestly oppressive, especially towards women. I'm thinking now of a Court of Appeal and then later Supreme Court decision in Nigeria, and the two parties were Mojeko and Mojeko, so we call it the Mojeko decision, where the court was considering an inheritance norm that was, I guess, indigenous, or the argument was that it was indigenous to some communities, to some Igbo communities in eastern Nigeria, and the court, in my assessment, appropriately invalidated the norm. But the court framed the traditions of received English law in its judgment, especially the Court of Appeal judgment, as intervening to rescue women from this oppressive system. And thankfully, we have received English law and we have the rule of law. And now we can apply these principles, and now this indigenous system cannot stand. I mean, the Supreme Court decision was a little more measured. Ultimately, the norm was invalidated, but I think an important thing that the Supreme Court decision did in that case was to say, we also need to understand that indigenous normative systems need to be evaluated in their own context, right? And reading that decision, I come up with an important truth, which is that pre-colonial norms emerge as peculiarly and particularly oppressive within the walls that colonialism built. And so in the Mojeko decision, that world is the world of private ownership and alienation of land for private and personal use, such that if you exclude women from inheritance in the normative system, it becomes peculiarly oppressive. But pre-colonially, where land functioned under like a cola tenancy system, and individual private ownership and inheritance of land is much more nuanced, we can appreciate that the gender difference that we see does not track along the lines of oppression as we think about it in our modern system, but more towards preserving communal land. And so the Supreme Court sort of made that case. Now, to connect all of this to law and literature, again, like I said, in my PhD work, I'm working with Chinua Achebe's text, and so that also means that I'm reading, as it were, and I use this term loosely, but fan fiction, so stuff that has generated from Chinua Achebe's text, more appropriately paratext, not fan fiction, paratext that have branched out from Chinua Achebe's text. And one of those texts is a short story published in the New Yorker magazine in the late aughts, I want to say 2008. It's called The Headstrong Historian. And in that story, the concept of the story is that a young woman who received colonial education eventually finds that her grandmother's experience of indigenous life in an Igbo village is a meaningful guide for her own, all these many years later, subsequent career as a historian and sociologist. And the argument is that the truths about Indigenous life, Indigenous society, pre-colonial community survives the machinations of colonial education. But how does this surviving take place? It takes place because the tools that Indigenous communities have historically used to preserve their record, to tell their stories, is literature, is storytelling. And so even though, colonial education can superimpose and even purport to supplant by insisting on writing systems or insisting on a formalized approach to literacy, so long as pre-colonial communities are able to preserve the storytelling praxis of, Indigenous methods, what eventually happens is those stories make their way using literature, as it were, into modern texts that we can access today. And so in the Headstrong Historian, we have access to remarkably strong moments of female agency that simply is inconsistent with this framework that we have popularly and in scholarship about how Indigenous systems were oppressive against women. And so that's what I get excited about when I do lower literature theorizing in the context of Indigenous literature, is that we get to see these glimpses that are often misrepresented when we think about formal scholarly text. And now I will comment to you something that Chinua Achebe said, where he was like, when he says that when he writes in English language, he's doing something unique in the sense that he is working with a new type of English language. He's expressing the Indigenous storytelling methods through English. And so it's a version of English language that is connected to England and the colonial system, just in terms of the technicalities, but it's also removed from it in the sense that it's attempting to capture a uniquely and distinct Igbo expression, Igbo praxis. And when I do law and future scholarship, I have that at the back of my mind. I have that at the back of my mind when I read text of Indigenous literature. It's that while it's accessible to me because it's written in the Latin alphabet and in English language, it's capturing a uniquely Indigenous expression, and in that way it can serve decolonial scholarship or decolonial practice or work that is attempting to move beyond the boundaries imposed by colonial education.
I guess just to kind of, this is a great conversation to kind of like tag on the back of that and think about the idea of how law and literature can open up those sources and methods that we can use as international lawyers. So one of the things I was going to add was that diversification of the sources. So one example I've been working on to think about where are women within constitutional drafting and constitution making, and not just thinking about mere participation, which is often what we focus on feminist constitutionalism, but to really kind of broaden up where we need to be looking. And one of the things that I found was in the early 20th century in Japan, women for a long time had been excluded from participating in political parties, and so instead had turned to literary magazines. And in 1911, in the literary magazine of Sato, there are 2 manifesto poems as the opening texts of that literary magazine. It's kind of known as a Blue Stockings magazine, would have been a kind of early 1900s women's magazine where they disseminated short stories and poems. And there are these 2 poems that are read as manifestos for calling for revolutionary constitutional change with respect to the role of women within Japanese society. Now, as an international lawyer, as a constitutional theorist, or as a constitutional scholar, that's not where I'm supposed to be reading to kind of find participation or advocations for constitutional change. And yet that is an example of literature being able to diversify the sources that we look to, which I think kind of reaffirms what you were saying there, about the storytelling as being part of record keeping, and therefore that necessitates the need for us to branch open and break open the types of sources we're looking at. Another example, much more relevant to international law than my constitutional theory, is Moderate Fonte's The Worth of Women, which I happened to go and see as a play production in St Andrews at the start of last semester. It's actually a 16th century text in which Fonte is mimicking the types of literary conversational dialogue pieces that would have been published by men in Venice and throughout Italy at the time. And in this text, she's imagining, the characters are gathered in a garden and the women debate whether or not they should get married. Basically, The Worth of Women is really about the worth of men. But what is so useful about this particular piece by Fonte is reflections on the idea of the sovereign and the role of the sovereign in navigating that debate. And so they elect a queen as their sovereign, and it's a discussion then about her role in mediating this discourse between the two groups of people. And in a recent piece, which could all go horribly wrong when it's been peer reviewed, I argued that the sovereign in Fonte's text doesn't actually ever make a final decision. She doesn't act as the sovereign. In fact, she renounces her sovereignty before she passes judgment and then defers judgment. She says, I'm not actually going to decide who won this debate. And so looking again, rather than at political treaties, but looking at the literature that was produced in the 16th century by Moderato, by women, can also offer us these kind of political theories on what they considered the role of the sovereign to be. We haven't found that in kind of political texts, but we found that instead in these literary sources. And I think so that's kind of like, opening up our sources, but it also opens up our methods, that idea of storytelling. And I've been prompted by this particular seminar to again revisit Yoriko Otomo's Her Proper Name, the poem in the London Review of International Law, where she imagines revisits Westphalia, kind of the beginning of international law, and inserts this imaginary voice, imagines what the voice of a contemporary woman would have been talking and discussing about at the time. And kind of that, almost that turn to literature, that turn to storytelling, and taking on the kind of the feminist imaginary that is so important within feminist movements and within feminist practice, to kind of open up our dialogue on what international law could have been, kind of, but bringing in that sense of that contingency and that alternative possibilities using the methods of literature.
If I may just real quick piggyback on something that Ruth said that I found really striking, which is when you talk about diversifying sources and methods. And I think it's so important within the context of law and literature scholarship, because often, and perhaps this is just a function of how I came to the field, often literature is framed as an important supplement to the formal sources, so an important context provider for formal proper sources, which would be the case law and the legislative text and the text of treaties. That's where we derive. And I understand it, Ian Ward has talked about how both lawyers and historians are interested in the question of provenance. And so it makes sense that, they would veer towards these traditional formal sources. And even Houghton talks about literature being useful to provide the human side of the law. And so it's thinking about it as a complement to the ideal. But what I'm picking up on what Ruth is saying is that, for sure, it's useful and it's a worthy enterprise to do that sort of work, but there's also important utility in thinking about literature as capable of standing as its own source of law, as its own method of providing legal scholarship. And to, if I may, connect it back to the type of work that I do, I think that if we draw from the formal sources, we run a very close danger of misrepresenting the communities, because it is not inconceivable that colonial systems, colonial methods, colonial anthropological projects would simply not have been able to understand pre-colonial society. I'm trying to remember her name now, but we have this literary scholar. I know her last name is Anene. I can't remember her first name, but she talks about how within the context of colonialism in Nigeria, for example, the European anthropologists, sociologists, historians who came tended to listen to, the men's representations of their society, which again makes sense when we think about how European society at the time was structured, such that men's account of pre-colonial life made its way into the formal accounts of pre-colonial society. And those accounts did not quite represent the fullness, including the gendered fullness of women's place in pre-colonial society. And so the formal text will tell a story of women being sidelined, but the stories that have made it through time into our literatures and into our storytelling traditions provide a much more rounded out and nuanced account. And this is a disclaimer I always have to give when I present my work. It's that I'm not saying that the pre-colonial societies were bastions of justice and equality and fairness. I mean, like any system of social organizing, they were vulnerable to othering, they were vulnerable to marginalizing folks, and including along gender lines. But rather, the argument is that it simply is inconsistent with the stories that have come from, the people's storytelling traditions to say that women had no place in that society. We know, for example, that the Earth goddess in Igbo pantheon, who and the Earth goddess would be considered like the primary source of both legal and spiritual authority, because it was often intractably entangled, spirituality and legality in those societies. The Earth goddess is gendered female, right? The priestesses for some of the key institutions of law and spirituality were female. We see and we know that there were multiple accounts of women acting as key rule enforcement agents. That history is inconsistent with what made its way into the formal text, such that we can have a judge all those many years later talking about how thankfully received in these traditions can rescue Igbo women from the oppression of indigenous custom. There's a tension there, and I think literature and law and literature methodology is an important way to make sense of that tension of why the two things don't track. So again, just to affirm, as it were, Ruth's argument about literature being a way to diversify our sources, diversify our methods, and diversify even how we present legal scholarship. Yeah.
Great. Thank you so much both for this very fascinating and really thought-provoking conversation, which I guess compel us a bit to challenge our own assumption about what law is, and which the associated dogma of truth, neutrality, impartiality, but rather question actually the construction, the discursive construction of law that can happen and happens, as you demonstrate, through literature. So we are approaching the sort of final ends of the second part of our seminar that dedicated to the Q&A. But before opening the floor to our audience, I just wanted to ask if you could share a bit with us, and maybe we can continue this conversation later on in Q&A, whether you think in which way, I know you've touched a bit on this already, both you, Ruth and Ola, but in which way can fiction and literature contribute to reimagine, legal practices that are really inclusive or decolonizing, or what could be the possible limitation, I guess, is another way to put this question. So if you could share quickly your thoughts before we open up to everybody.
Ruth, do you want to go or I can go? Okay. Look, I could see you looking. I thought you were trying to give me a sign to go. Okay, I will go. I think that I think it does no scholar any good to hold out their preferred methods as infallible. I think any approach that we take to scholarship will always have, its strengths and its drawbacks. And so I'm not unaware when I talk about law and literature that literature is subject to the whimsy of the storyteller, as it were, right? And so that's something that I hold out, that I foreground in my mind. And so often when I'm working with literary representations, I'm also reading different people's accounts of the same incident and including the formal traditional sources to see how we can distill a shared truth. So that's often the goal that I'm going for, a shared truth, as opposed to if the fine details, as the storyteller has put it, is factually accurate. I don't think it serves the purpose of scholarship to attach much weight to the fine details of literary representations when I'm doing the type of sort of analysis in law and literature that I'm doing. And I will commend to you, within the context of my research, two texts, as it were. So Chinua Achebe's Things Fall Apart, that's much celebrated text of African literature, Things Fall Apart, right? One of the criticisms, or one of the things that, critical analysis of his work has received, is that it's very male-centered. So we have male protagonists, and the actors are male and the women play a supporting role. And this criticism has come from both women and male scholars alike. So and that's true, but I also think that it's a function of how literature as a genre is. People are often moved to put their own sense of the world, their own experience of the world into text. And so on the flip side, we have the short story that I mentioned earlier, The Headstrong Historian, which takes its inspiration from Chinua Achebe, a plot line in Chinua Achebe's story, and then offers a female perspective on the experience of colonization in Igbo land. So Where Things Fall Apart offers a largely male perspective. The Headstrong Historian offers a female perspective. And so in reading the two texts side by side, we can come up with a shared truth. And so if Chimamanda Adichie is offering us this story about female agency, and even in Achebe's male-centered universes, we also see strong stories of female agency. We can distill it as a shared truth that indeed, there was strong female agency in Igbo pre-colonial communities, whatever the formal accounts or the colonial accounts might have represented. So to be sure, there are limitations to working with law and literature methodology, but I don't think it's unique to law and literature methodology. I think there are limitations to working with any type of scholarly methodology. And the task for the scholar is to be humble enough to know the limitations and not try to stretch their arguments beyond the capacity that their methods are using. And that's what I try to foreground when I work with law and literature.
That's great. And I think in terms of how can literature then, or the study of literature and fiction, be used to reimagine international law, I wanted to speak particularly, or the intervention I was going to make was with particular reference to utopian fiction. So utopian literature, often found these days within science fiction, offers what Suvin argues is cognitive estrangement. That makes it possible for us to imagine a world without and out with the constraints of modern society. So it gives us the tool to imagine, to reimagine international law as what it could be, without the kind of the strappings of the gendered, racialized, colonialized heritage and structures that it comes with. But utopian fiction in that cognitive estrangement also forces us to then think about why we currently are not there. What is it that is currently lacking? What is it that is missing? Ruth Levitas's utopia as method is really instructive here. She talks about utopia as having an archaeological aspect and an architectural aspect. So in the archaeological aspect, we have to look for those previous and historical utopias. International law, China Mabel might tell us, is that we live in someone's utopia. It's just not ours. And so using Levitas's archaeological method, we look to international law's utopian project and say, who's missing? Who's excluded? Who's harmed? What's the harm and the causes of these gaps and inconsistencies and structures at the core of international law? But in the architectural aspect that Levitas gives us, this is where we need to think about a more critical utopia, a utopia that is not a blueprint or a destination in the future that we're going to get there, but rather a continual process of self-reflection and interrogation. And the two examples that Aoife and I often come to in our work about this provisionality or reflexivity within utopia is actually to jump back on something you said. I hadn't thought of it as paratextual, but I'm going to punt this out there, which is the conversation that happens between Ursula K. Le Guin's story about walking away from Omelas and N.K. Jameson's stories, the ones that stay and fight. So Omelas for Le Guin is this utopia at the center of which a child is strapped to a chair and has to bear the entire harm of that utopian society. And Le Guin is basically like, when you find out that there's harm there, do you just walk away? So it's about those that walk away from utopia. N.K. Jameson in reply writes the ones who stay and fight. When you realize that your post-colonial utopian project is being infiltrated by the previous harms and racism of what was Earth, what do? Just walk away from your new utopian project? No, you have to stay and you have to fight. And so it's almost that continual process that is utopia. And so I think that for me, then, thinking about utopia as a method and using these stories, these critical utopias that often at the center of them have a fault line. Matthias Thaler would tell us they often fall apart, they fail. But in that fault line, what are we being forced to ask ourselves? We're being forced to ask ourselves, what is it about current society that means that utopian project is not possible, and therefore we interrogate the current utopian projects for their failings. But also, what might it be? What might it mean that we need to stay and fight and work towards in order to bring about this alternative, this reimagine, this new possibility of international law? And perhaps, yes, as you say, we can open this up into questions and into discussions, and I won't keep any more time of the floor.
Right. Thank you so much. This has been extremely illuminating, and I hope everyone joins me in thanking you for these incredible insights. But yes, we'll now transition to the Q&A.